obviously the ones that come to mind, first of all, are going to be New York and California. Their penalties are much more severe. Well, actually, they're obviously way more severe than ours because we have none now. But this bill is mild compared to what you can be penalized if you were to break a law or not adhere to a rule when it comes to these issues. Matter of fact, I think California even, you can actually serve jail time on theirs. And we're not asking for that. We're looking at monetary fines only. We also do have some other tools with certain industries, and this is probably more specific to the film industry. We can deny future productions the ability to hire minors if they abuse it. Of course, as we all know, I mean, like any other business, you can just come up with a new business pretty quickly and start from scratch, and then obviously that doesn't follow. But that's basically what we're trying to do in a nutshell, is give our laws and rules concerning minors in the workplace some teeth, and so we have some enforcement, and we make sure that we're keeping these kids safe that are in the workforce. And so I'm just hoping that you guys will take a look at this and give due consideration at the proper time, so that way we can actually enforce these laws that we currently have on the book, and also the rules that we have worked very hard with industry, by the way, and others to make sure that we're covering all of our bases.
All right, thank you, Commissioner. And yeah, it wouldn't be a full session if we didn't see you at least once in this committee room. So,
well, I thought we was going to get away with it, and then here we are. So
but I do have a question for you. As I looked up everything on this bill, and I'm not the greatest on looking up all legal sections, but 39-2-20 is entirely nothing but minors. So this doesn't apply to anything but minors. I couldn't see any way it could be crossed over to anything else.
No.
It looks like they've trapped it pretty good. And that's your
yes.
your opinion as well. Thank you. We have a few questions. Representative McLean, number 17.
Thank you, Mr. Chairman, and thank you for Commission for coming and I guess definitely bring us at least to a hearing. The definition of minors is we're saying
Under 18.
under 18, good one, and if I can follow up. So the tools that we do have, it's not anything with child labor laws at all, or just.
I mean, for this particular instance, I mean, you know, you're taking a look at certain industries that really concentrate on hiring minors, whether it's the film industry or you have, you know, obviously retail in some cases, amusement parks in some cases. Obviously, I mean, there's going to be some seasonal jobs. And, and I'm not picking on the amusement industry by no means, but you can see that in that industry, obviously, there are some areas where you could, and we've had instances in the past. Way in the past where you've seen somebody, and I'm not saying it was the company's fault or whatnot, it could have just been some carelessness on the individual, but still, we're still talking about somebody who is, 16, 17 years old. Sometimes, as we all remember from our youth, don't have the world's best judgment. So it's up to us as the adults in the room, so to say, to help them with that judgment. But I mean, obviously, these things are going to be used, in cases where you've got somebody who is, I mean, you're not talking about, a case where it's an accident, but you're talking about somebody who is, willfully putting somebody, in a bad situation and that they should not be doing, I mean, and when you have somebody who is a bad actor, we'll come in there. I can tell you that we do work with all industries, including, film and retail and whomever. And we try to get them to correct their actions first. I mean, we're not looking to go out there and find people just for the sake of, creating, revenue. That's not what we're trying to do. But this is put out there so we do have a way, if we do have bad actors, that, I guess I shouldn't use that term, but a way to where we can actually do something with it. Because right now we can't, and we do have a few out there that they know it. They're like, what are you going to do? I mean, you can't do anything to us. I mean, you can sit there, you can do this or whatever. I mean, and quite frankly, you take a look at the $1,000 fine, you take some of these companies' $1,000 fine, I mean, they spend that on catering that morning.
And I guess, Commissioner, I guess that's my follow-up is that I don't see anything, I mean, if you just keep continuing to do this habitual, I just think we just need to go just a little further myself, is that if you're going to be acting bad, we just need to do, I don't say the death penalty, but
as I used to say, is let it be the will of the committee. I mean, if you guys have got some ideas, this is something that that we came up internally and also working with the chairman to come up with something we thought would be fair a starting point. But I mean, I'm, obviously willing to listen to any type of suggestions you may have. There's also another bill out there right now that deals directly with the film industry, and it has to do with imposition of loss of credits, film credits, if there's a really, really bad actor. Of course, I don't know where that one's at now. We haven't had a hearing on that one yet either. But I mean, there's other things that are being looked at. But we're talking about a lot of changes right now when it comes to different areas. And when you're talking about minors, I think that's one of the areas we definitely need to make sure that we're protecting them, because we do seem to have a lot more activity on that. In this economy, we're seeing a lot more minors in the workplace right now, which is good because we want them to work. We want them to get that experience. So that way we don't want their first job to be when they graduate college and they've never worked before. But we just want to also make sure they're safe. And if we do have people that are abusing the system, we need to have a way to where we can correct it.
Thank you.
All right, number 16, Representative Park.
Thank you, Chairman. Thank you, Commissioner, for the bill. I had a few questions. So just to clarify Chairman Kirby's point, this bill does nothing to add to or amend any other existing rules or regulations when it comes to the employment of minors. Is that correct?
No, because this will be the first time we have had penalties involving, any type of breaking of the rules or laws of minors. So, this does not, technically, yes, it does change, but this is new.
So to be frank, so this wouldn't cut or end the dream of a child who wants to be a child actor
Oh gosh,
or something
no.
along the lines.
No,
Okay. A few more questions, if I may. So in looking at the chapter of this title, specifically sections 39.2.19 and 39.2.21, there does seem to be provisions under Georgia Code that allows for rules and regulations to be promulgated by your agency to enforce the other code sections that regulate employment of minors. And injunctions may also be filed to prohibit certain entities. Just curious, have those been inadequate in regulating some of the newer employment of minors?
Right. I can tell you that, if you're talking about, I can tell you, for example, we had an issue several years ago with a retail chain, and it got worked out pretty easy. It wasn't, an issue, it's a big one, and they were great. They said, okay, yeah, let's work this out, no problem. But where this really has come to light has been here, and I promise I'm not trying to pick on the film industry, because we go to a lot of locations, and 99.9% of the time they are on top of it. Matter of fact, they're the ones that actually pushed us to create tougher rules, to be quite honestly, and because they hadn't been looked at when I became labor commissioner for 30 years. We had the same stuff on the books, and we have worked very hard over the last, it's a constant changing thing over the last, I would say 6-7 years of constantly working with them and having meetings and hearings and input and changing those rules. But when you have an instance where you have a temporary employment situation, whether it's film or if it's amusement or if it's anything else like a summer job, by the time you go through the process you're talking about, they're gone. It's over. You need something that's more immediate effect. Otherwise, it's like the one time, since we've been having the influx of film, we've had one film company that really stuck out that just kind of just told us and just brushed us off. And by the time we started making the phone calls to do what we were talking about, they'd gone home. It was over. There was nothing we could do. Of course, the only thing we can do is if they try to come back under that name, under that company, then obviously we're going to say, nope, sorry, we're not going to issue the permit. But in their case, they didn't even go do the permit in the first place. And so we had somebody turn them in.
Again, I would be curious to see kind of what the department's rules and regulations are to enforce any of these provisions, if there are any that have been promulgated. And I think this committee, does not want to get into an argument or a debate over the difference between a rule and a regulation. I think we've spent enough time on that. But I think just out of my own curiosity, but otherwise, I think, I'm generally supportive of the bill. I think it's makes sense.
All right, number 23, Representative Kennard.
Yes, thank you, Mr. Chair. Thank you, Commissioner. What about a kid who's just shadowing their parent who's an employee on a film set or and they just want to learn the industry a little bit, hanging out with their mom or dad that day.
Don't really think that really kind of covers that, because then they're there under the supervision of their parent. So that's like it would be in any situation if you were anywhere.
Right.
So I don't think that.
So this
covers-
doesn't apply to that?
No.
Okay.
I can't see, I mean, one of the attorneys who may be up here, I don't know who's attorney, I am not one. Maybe y'all can connect those dots. I'm not that. I didn't do that. So, but some of y'all who are attorneys, y'all might can figure out a way to connect that dot, but I'm not trying to connect that dot, so.
Yeah. I think in most child labor laws, they're exempt if they're working for their parent. I think.
All right, number 27, Representative Holly.
Thank you, Mr. Chairman, and thank you, gentlemen, for presenting this. Commissioner Butler, you definitely work at this. I wanted to know if you could better expound on exactly the measures that your department already puts into place to make sure that these companies are in compliance,
Well, we do have, not say licensed, but we do have some authorized inspectors who go out. We do spot checks, which that just means that, if we know, because they have to register, and also we know the companies that employ in other cases. So they can basically show up unannounced and make sure that, all the provisions are being adhered to. Like, for example, you're talking about film, there's educational requirements and have tutors and advocates and things like that. All that stuff's got to be, in place, and basically they just go through there and check the box and everything's good, and they work with the film company saying, okay, this and that, and like I said, 99.9% of the time, there is no issue. So whatever. I mean, they are very good at keeping up with the laws and the rules and the regs, because quite frankly, they're used to working in other states who are even more stringent than we are. And we've got good rules and laws in place right now, but there are obviously some states that are even more so. And so a lot of times they will err on the side of those more stringent rules that they're used to. Like if they, doing a lot of film in California or
Right.
New York, a lot of times we'll notice that they're actually abiding by, in some cases, those laws, because they just kind of keep into the practice.
Gotcha. Thanks for that clarification.
All right, anybody else have any more questions for the commissioner or the chairman? Nobody's lighting up. Mr. Chairman, did I hear that you might have some kind of change you're looking at?
I do, and I don't know if and one of the reasons we need to do a hearing, because this all came pretty quick. So, starting on lines 19, basically section 2 would be replaced with, and so since this hearing we'll have this ready in time. So we'd remove section 2, starting on 19, and it would say any person, firm, or corporation or agent thereof who employs a minor child and acts with specific intent to evade or avoid the jurisdiction of the Department of Labor shall be subject to additional civil penalty not to exceed $10,000 per violation, which shall be assessed in addition to the penalty provided in paragraph 1 of this subsection and collected as provided under paragraphs 3 and 4. And where this came from is the commissioner mentioned, we've got another bill in Ways and Means that's very similar, but it is specific toward the film industry. And so some of the thinking, rightly or wrongly, was if the film industry is basically an employer, the question is being asked, why are we separating the two? And as the commissioner said, up to $1,000 is too low. So why not, in the same sentence, broaden the scope so that it involves all employers? Because if you're a bad employer, doesn't matter what industry you are, but then raise the cap up to $10,000. That doesn't mean if someone is guilty of an infraction that you would fine them $10,000. It would give the department some latitude, depending on the severity of the fine. But the thinking was it would negate the necessity, especially this late in the process, of having the Ways and Means bill, and we would just have one bill that would capture both thoughts. Now the downside of that, or possibly the downside is, but some people might like this idea, that it would not touch the tax credit. It would merely be a monetary fine. And my apologies to the commissioner. He hasn't even seen this amendment, so kind of off the cuff response from him, and with knowing that you haven't even had a chance to look at that.
Well, the only thing that I heard you say was, I think you meant to say on line 15 instead of 19. Because you would
15 would stay.
because, no, you would definitely want to keep number 2 because that's the, that allows, for appeals.
Sorry. Yep, you're right.
Because we have to, you have to have due process.
Yeah, so what I just said would replace 15 through 18.
All right. Well, and I think most of us agree that we're always wanting that balance with the film industry. We like for them to come here, spend a bunch of money, and go home. And we don't want to put in place things that would make them not come here to begin with. So I don't know, 10,000, what's the right amount? I think that's a balancing act that we'll continue to work on. So, but that did create a question. Number 26, Representative Carpenter.
Yeah, thank you. So I'm just making sure I understand this. So you're wanting to replace 15 through 18 and change it to not to exceed $10,000. And is everybody under the assumption that usually, you know, when my wife asks me for money and I say I will give you up to $100, how much money does typically my wife ask for? $100. So when you give an option, when you give the option of $10,000, it's going to be $10,000. I'm just making sure we're all, and I understand it's up to, but like everything, we're having a conversation. It will be $10,000. Just making sure we all understand that.
And that's fair, but the other side of that is, because you could make the argument for the other, if you do the low extreme, and I'm not saying I don't disagree with you, and that's why I think it's important that we have these discussions now and don't rush this out. But the other side of that is, if you go the other extreme, you know, these film industries are spending $200-300 million on a project. $1,000 could be seen as a cost of doing business is violating, but I totally agree with you. That's a fair point.
Well, and I can assure you that it wouldn't be
25.
$10,000 every single time. We do use good judgment at Department of Labor about this, and the appeals process eventually does come up to me. And I may not have multiple degrees and things like that, and I may not be a Mensa person, but I was blessed with a whole lot of common sense.
Just follow up. So, and I don't disagree with that, and it's not an attack on you, but you're not going to be there forever. You know,
I
there'll
hope
be a
not.
day in Georgia law when you're not there, and the next guy may not have we may not have the luxury of having somebody that has common sense to address these issues. So I think that's a concern. I think also a concern is, you know, these minors typically have adults in their lives that are allowing them to participate in these films. So at some point, as a society, if their parents are okay with it and the film's okay with it, you know, yes, $1,000 is just the cost of doing business, but at some points, a lot of people are in agreement with this situation. So it's just a slippery slope when we start slapping $10,000 fines on people when there's a lot of agreement that have been done before the situation occurs. It's not like they're going out taking these kids out of somebody else, ripping them out of somebody's hands, forcing them on these movie sets with chains and whipping them, saying, I need you to, I mean, we're all, you know, that's the problem I see.
Well, from my point of view, the way I look at this here is, everybody has a choice whether or not they're going to go to work at. I mean, like when I was a child, I worked at Walmart from the time I was, I started working there when I was 15, about 2 months before I turned 16, and worked there until I graduated high school. All right. Yeah, it's a choice. But, you know, we're not talking about that part. We're talking about whether or not, you know, that the people that are put in response, like, you know, my parents didn't go to work with me every single day at Walmart. Thank God. That'd have been embarrassing. But I had bosses there that ordered me around, told me to do things, had me do this, had me do that. And they do have to be responsible when they're dealing with somebody who is a minor, who is not an adult, who may not know better at this current situation. And so it is our responsibility, Department of Labor, to make sure that everybody is doing what they're supposed to be doing. And I would hate for a future labor commissioner, including this one that's currently a labor commissioner, to get in a situation where somebody is seriously hurt and that microphone gets stuck in my face and goes, well, what are you going to do about it? And I'm going to say, right now, I just say, nothing. I mean, there's nothing I can do. I mean, what do you want me to do? I mean, you know, I can call the AG and see if he can come up with something, which is kind of where I'm left at right now. I mean, and, you know, and by that time somebody's gone. You know, you don't know where this, you know, whether, who you're dealing with. So, I mean, but it's not a good situation to be in right now, to be in a situation where if there is something that happens and they go, well, how come you haven't done anything? You know, this person, like this one of the examples that I gave is somebody who is constantly we've had issues with. We know we've had issues. There's a record of them having issues. And the question is, well, how come you haven't done something? Well, it's because, you know, we don't have anything to do anything to them. I mean, we can't. I mean, there's, you know, in that case, and it wasn't a film company, it's actually something else. And there's actually are no provisions to where we can do anything like what was discussed earlier. So I'm kind of in a rock and a hard place. I think just like everything else that's out there, if you mistreat somebody, there's a penalty of some kind, except for in this case. In this case, to me, it's the most important one because you're talking about people's kids. It's just like if anybody up here had a constituent and that constituent was harmed or hurt or mistreated on the set, or things weren't provided for them like they're supposed to, and then one of y'all called me up and said, what are you going to do about it? Right now, I'm going to say, well, we'll go out there and inspect it, and we'll tell them to quit doing it, and that's about all I can do. That's where I'm at right now. And I don't like being in that, I mean, you know, in that spot. I need to have some type of ability to do something to correct bad behavior. I'm not looking to enhance revenue by no means. You know, if it's a small infraction, I can go ahead and tell you they're not going to get fined in the first place. They're going to get a warning and say, you may not know this, but you cannot do this. You need to correct this, and we'll be checking on you later. All right, and if they do it the second time, then yeah, they're probably going to feel a little bit of hurt. I mean, you shouldn't have to tell somebody twice to protect the kid anyway.
All right.
Honestly.
Representative Bonner, you got a question?
I do. Thanks, Chairman. First of all, I agree with Representative Carpenter's line of thought that when you make it 10,000, that that it may not for you, Commissioner, but chances are at some point it's going to be there. And secondly, we started off the presentation with we're not targeting the film industry, but all the examples that we've cited have been related to the film industry. So I'm just trying to think through, you know. Are we going to penalize the film industry with a $10,000 fine because they can afford it, or because it's the right thing to do? Versus, and I'm thinking about, you know, like small landscape business. I mean, what are we going to? I agree that we need some teeth in the law. I'm just a little hesitant to give it that much bite.
Well, just whatever y'all think that safety of the kids are worth is what you probably should need to put on it. I mean, that's kind of where we're at. That's what's going to be asked of me. I can go ahead and tell you.
All right.
I guarantee if it was yours, I mean, you'd want somebody to be able to come in there and correct some actions. I mean, we've already had some of them come to us right now about some issues that, you know, we didn't even know were actually an issue. We had to be educated on it, and then we've had to go back and do emergency rules to make some changes. But if the company wants to go back and break those rules, there's nothing I can do about it. We actually had an issue here recently with artificial smoke on set, which, okay, yeah, you say it all the time, no big deal. Well, there's some stuff out there that says that the chemicals that are in the artificial smoke are as bad for you as some of the stuff we're hearing about with some of the vaping stuff. And then we found out that we had some minors on the set with artificial smoke. And so we're like, well, wait a minute, that's an issue because now you're endangering the health and welfare of a child on a set. So, you know, I mean, because we didn't know anything about it until somebody came to us and showed us the information. So, I mean, you have to put that stuff out there. I mean, but, I mean, right now, if somebody wanted to keep using that, we can say, okay, you broke the rule. What are you going to do about it? I mean, and I'm not trying to be smarty up here or anything. I'm just telling you that I don't think we should, you know, it's like any other thing we have out there that we create a law for that we want to stop a bad behavior or prevent a bad behavior. We don't go ask the people that may commit the crimes, what do you think your penalty should be? And I want the film company to be, and look, you can, I don't care who you talk to in the film industry, but I can guarantee you this, if you can find one person in the film industry that will tell you that we have not had an open and fair process about creating the rules that we currently have in place right now, they're a liar, because we have listened to every single input from every single side. We have bent over backwards. We have got one of the best, we've even gotten letters that have commended our process from SAG. And it's saying that, you know, your people are great, they are listening to us, and it's not me. This is people, you know, those other people you're talking about, you're worried about having common sense. They've got it. I mean, they're like, we understand what the mission of Georgia is. We're not trying to run anybody off, but we do have to be able to do our job. We have to have the tools to do that job. And that's kind of where we're at right now. So, I mean, if you want to make it 50 cents, make it 50 cents. If you want to make it 10,000, make it 10,000. But it needs to be something. I mean, that's why, you know, I think having the, you know, I actually was more in favor of being able to take some of, not all of, which, you know, somebody took that way, of tax credits. If you had somebody that did something really egregious, that's the only thing that's going to get anybody's attention. If you have somebody, you know, that ends up losing a limb, an eye, or their life, God forbid, what's the penalty for that? Of course, somebody says, well, then they'll just go to civil court and they'll get sued. But yeah, I mean, maybe there should be some criminal penalties too. I mean, like, you take a look at I think it's the California, you actually can go to jail for some of this. There's jail time in theirs. And some people say, oh, we don't want to do that. But I mean, it's there. I've got it. I've got the New York and the California code. Now, obviously, we're not going to go that far. But I mean, they have something in there.
All right,
Or you could have it, you know, you could even break it down and say up to, you know, 5,000. But if a minor is hurt, maimed, or killed, you can increase that 4 times.
Would OSHA come in under those circumstances if there was a death or an injury?
Yeah. It'd have to be the feds, though. I mean, 'cause we don't have that here.
All right, we've got a bunch of lights now. Representative Carter, number 15.
Thank you. Mine is a simple question. Would you reread the amendment, please?
Let me make sure. Okay, I know I was confused now because they made theirs, they swapped out the order 1, 2, 3. So it's number 2, but number 1 on the other one. Any person, film, or corporation or agent thereof who employs a minor child and acts with specific intent to evade or avoid the jurisdiction of the Department of Labor shall be subject to an additional civil penalty not to exceed $10,000 per violation, which may be assessed in addition to the penalty provided in paragraph 1, or I think it'd be 2 in the original, of this subsection and collected as provided under paragraph 3 and 4.
So I think I see what the person is trying to do. What they were actually doing, and how he read that, they were inserting an additional paragraph and renumbering after that B1 that you've got right there on the first page.
Right.
What he read would go on 19 and then push everything
Right.
down
Right.
and renumber,
Right.
is what he's saying.
Right. Okay.
So you would start off at 1,000, and then if you have the more egregious, it can go up to 10,000. So that's how I heard it better that time when you read it than I did the first time.
All right, 17, Representative McLean.
Oh, thank you, Mr. Chairman. And also, I guess to Representative Carpenter's, and Bonner's suggestion, I think that from a person who I guess got fined, I didn't get fined a lot, but I got fined quite a bit. In football, they fine you for overweight, they fine you for being late, but it's always a progressive type fine. It's like, okay, do it the first time, you overweight, you fine $200 a pound. The next time I was overweight, I was fined $350 a pound. But then all of a sudden I came in on my weight because money does make a difference. Is there some way, I guess the way we were doing it is that the first time it's $1,000 and the second time was up to $10,000? Is that the way that I heard it?
No, I think there's some extra provisions that have to kick in. Basically, you're willful, and it's shown that you are willful, that you are trying to evade. I mean, that's where the 10,000 kicked in when he read it the second time I heard that.
Right. I was just, in essence, how we were always fine was first violation, this is what I'm charging. The second time, I'm charging you more, and then you know, and then sometime in my profession, you do get the death penalty, which you can't come back. But
Yeah, the way I read it, and obviously I know I would like to see it on paper, and I know you would like to see it on paper also. But the way that when I heard him read it the second time, it sounds like that for just your normal violations, then you can up to 1,000. But then if you get into the point to where you're willfully evading us, those kind of things where you're obviously you have intent. Basically, what they're saying to break the law, and it can be proven. Then it can get up to the 10,000. That's how that.
well, I mean,
sounded to
if
me.
that's the way it's explained,
Yeah.
that's fine. Thank you.
All right, 27, Representative Holly.
Chairman, I think to my colleagues, Representative Carpenter and Bonner here,
Wave.
in terms of what they're expressing, is that because that range is pretty broad, from 1,000 to 10,000, and I know that you definitely need to have some teeth in the game, and be able to make sure that they are responding to the law, to make sure they're following it. Is there possible? I know just many times when you're looking at criminal code, that sometimes will hit people with that penalty. Is there a way to classify the behavior through which you can separate one penalty from the next? From that, there's, for instance, there's maybe 2 or 3 children, who are undocumented, unpermitted, and you hit them with 1,000, and then you can kind of graduate the penalties going forth so that you have a $10,000 cap in some way, just to provide some level of assurance that you're going to qualify that behavior and set a penalty per violation.
Well, I think that's because I'm looking at it now, so I can read it. But that's exactly what his proposed amendment actually does. It does give a separation between the two. The up to 1,000 is your run-of-the-mill issues, violations, usually after a first-time warning. But the up to 10,000 deals with a different category, and it's how it's worded in here, because it says, and I'll just read I'm going to cut it down, but it says, but any one of these, any type of corporation or entity, so it goes for everybody, that employs a minor child and acts with specific intent to evade or avoid the jurisdiction department. That means that it wasn't an accident that happened.
Right.
You were purposely, putting a child in a bad situation,
Right.
And not only that, but you were also trying to cover up the fact that you were doing that. And when you get to that, that's when it gets into the higher fines. But on the regular type stuff, if you're just talking about somebody who did not provide a tutor
Right.
the entire week for none of the kids, then you're talking about that would be in the $1,000. Especially if they didn't know they weren't showing up.
And I think maybe that's where it's going, is that in terms of that activity that is performed that actually ties into each penalty, it's good to be able to give a level of discretion there in terms of applying that, but also, are the actions, especially when we look at a specific intent, is it inferred or is it laid out in terms of, what actually makes the activity such that you can determine from the statute that they've been able to break that law specifically, like what that specific intent, because if not, then the tricky part is that anybody who looks at this and tries to apply it can say, well, yeah, I know you meant to do it. Yeah, I know you meant to do it. That's you were specifically intended to. Let's hit you with the biggest fine. Is there, if that can, it's hard to sometimes codify behavior into this, but hopefully, in doing so, you'll be able to have people, properly apply that fine to their actions. Suggestion.
But, keep in mind, there's also an appeals process that's built into this bill.
Okay.
It's not an automatic, and you have no choice, and you're just stuck with it. It goes to appeals process that you can go in there, and it, eventually, it can get all the way up to where I'm sitting there and I'm looking at it, or whomever is going, okay, and let's look at the evidence. And I mean, you could even, if you wanted to get really crazy with the appeals process, you could even throw a small thing in there to where, if your fine exceeds a certain amount of stuff, you can have the ability to take the evidence and go into superior court of the local jurisdiction and appeal there as your last point of appeal, just like we do with UI claims, okay? You can appeal all the way to court at some point, right? Which actually makes that process extremely long. And a lot of employers complain about it, but it's due process for both sides.
Gotcha.
And, we're very good at that.
All right, who's next on the list? Number 16, Representative Park.
Thank you, Chairman Kirby. So if there are any instances in which a violation may be occurring, are you saying that enactment of a fine would be the only way to prevent that violation from continuing?
Well, I think we all know that even if you have laws and rules and regs and fines and jail time, it doesn't always prevent it. But there should be some type of punishment if you do that. But now, we can. And there's certain things, you have to be able to certify that you're allowed to have minors on, in this case, I'm sorry, but it does go back to films because the process is set up to them. They have to certify, and it's been this way before I got here. If you're gonna have them on set, that you have to, you have to get a permit for that, okay? Because it is a temporary thing, and then you're gone. So you have to certify that. We used to, and we quit doing this, we used to make them bring us the entire script to see what was going to happen and where the kids were going to be, and we stopped that. And I stopped that for several reasons. And it came to light when, oh gosh, I'm about to mess up my pop culture quiz here. What's the one, Katniss? Somebody help me out.
Hunger Games.
Hunger Games. Okay, the Hunger Games came, and we still had the old rules. I didn't want that script within 100 feet of my office. If one of my people leaked that, they were going to come and get us and drag us off. And I was like, no, that's got to stop. And, then we said just a provision. And then we said, you know what, let's just do the rules and regs to where if you endanger a child, then these things are going to happen, all right? And so we did it on the back end instead of the front end. In the old way, we took a look at your script and we had to approve it. If you had a minor on set and said, okay, it's okay for you to have a minor in that scene. And now we said, no, we don't want to touch the script. We don't want to be anywhere near it because we don't want to have the liability of somebody on my staff going, oh, guess what I heard? They're going to kill off so-and-so in movie 3. No, we had to stop that and said, okay, we're going to put these rules in there. But then once we did that, we found out that, okay, if somebody does break the rule, what do we do?
So
Nothing.
if I may answer your question, Commissioner Butler, in the code section right under 39-220, it does give you the ability to file an injunction in Superior Court to stop any violation of this chapter. So I think to Representative Carpenter's point, I don't know if necessarily increasing the fines would necessarily prevent or stop harm from occurring that could result in a child being hurt. That said, I think to Chairman Werkheiser's point of having an amendment that has a $10,000 fine for a willful attempt to avoid is a whole nother matter. But again, I think I hear Representative Carpenter and Representative Bonner's point in that they don't want to unnecessarily add additional fines unless there's, again, an inability to enforce this section, whether through rule, regulation, or injunction, that, again, is clearly laid out where, upon a filing of a complaint by you, in Superior Court have the ability to stop any violation of the code section.
But if somebody's only going to be here for a week, they're gone, and that injunction is useless.
Okay.
And that has actually happened to us.
Okay.
Mm.
And it was like, we know that was a remedy, and we started to do the process, and we're like, okay, well, they're gone, so what does it matter now? They're gone. What do you do? They're gone. They've done it, they were willful about it in this case, and, the injunction doesn't matter. I'm not so powerful where I can just, the first time because, like I said, we go in there and go, hey, you got to correct this, fix it, and we told them, and they said, yeah, we'll do it. We'll get them registered, we'll put everything in the system, and then, we check on it a couple days later, still not done, and then when we go back to go do something about it, they're out, they're gone, they're out of town, bye. I mean, so what do you do then? Do an injunction on something that's not there anymore? I mean, that's kind of a waste of time.
Has your office filed while you've been Commissioner of Labor? If
For
I may
this type of
ask.
thing, we only tried to do it once in this case because it was, I mean, we've never had somebody that was quite that willful of just saying, no, we're not gonna do it. We're not gonna register the kids. We're not gonna tell you where we're filming. In this case, it was a film industry, and and then by the time we got around to going through the process and contacting the AG's office and whoever to represent us, they're gone, and so we didn't get to file because there was nothing to file against because they done left town. They're going back to wherever they came from, and so there was nothing you could do. I mean, this is not something that happens all the time. I think that we're worried that there's going to be this just mountain of fines and all this stuff going on, but we're really just looking for the very worst actors, and there's not that many of them. Like I told you, it's 99.9% of the time, these guys are doing it right. Or, if they're not doing it right, after that first visit and it's pointed out, hey, you may have missed this. You need to make sure this is taken care of. They take care of it. And that's all the thing we're trying to do is if when you have the ones, and to me, I find it shocking that somebody would do that after you've been told. Somebody sitting there with a badge and an inspector going, you need to fix this, and they go, we're not going to. I mean, what else are they doing? That's what you gotta ask for. And if you do have somebody who's like that, in the case of somebody who is in the film, and we're giving them millions of dollars in tax credits, and they don't wanna abide by Georgia's rules, I don't think that's right either. Because our rules are not that strict. Keep them safe. I mean, we're really not. I can get every single one of y'all a copy of all the rules that we've got. And it's a little book that we have that we give out to everybody. And it's not anything that's just insane or crazy.
Of course, you realize, Commissioner, we could have all been retired if we knew who shot JR that whole summer before they let it out.
Yeah.
Number 18, Representative Gilligan.
Thank you very much, Mr. Chairman, and thank you for bringing the bill, Mr. Chairman, and it's so great to see you, Commissioner. So just to make sure I am understanding, we already know that it is a criminal offense. It's a misdemeanor, right? That's existing code right now, even line 4, if you're violating this, guilty of a misdemeanor. That's a criminal offense, right? Somebody who knows law? Okay. So, right, line 14 is,
Oh, 14. I thought you said
line
4. Okay.
14, 1-4.
Yeah.
So already in code, and really that's the only thing that says right now, if you go to 39-220, is there and then it ends, right? So we are saying up to $1,000. That makes sense on a misdemeanor. But now we are adding a civil penalty. So we are going from the criminal into the civil with the up to 10,000. Am I correct? Right? Because as I heard from Chairman Werkheiser, it was any person, firm, or corporation or agent employs a minor child, willful, blah, blah, something civil. Remember the word civil. So that would imply that we're putting the civil code also in here, right? And I know you're working with the council who we don't have.
Yeah, it says, it does say additional to, an additional civil penalty not to exceed, and those are the ones that are doing the willful.
Right.
Like the case that I cited earlier where they basically just said, oh,
So here's what I find interesting. We have a criminal offense, but it's only a misdemeanor, but we are saying that you can also be filed civilly.
well, you can change it all to be all
Yeah.
civil, period, if you'd like. I
Well,
mean,
no, then my question is, do we want to consider, and maybe with counsel, should any egregious act be a felony and not a misdemeanor? Now, I know whoa, there's the pucker factor. But I mean, I'm just asking. I'm asking a real question because I don't know. And I'm hoping that with counsel from our committee, we'll have an answer. But it might be something, yeah, I know, let's go make every hair on the back of your neck stand up and think about that. But I'm just asking, since we're throwing in a potential civil violation of up to $10,000, and we're talking egregious cases.
Right, and and if I give you an example of what you're talking about, like the California law, this is how it reads, and it's very, very short. Criminal violations of child labor laws or misdemeanors punishable with fines ranging up to $10,000 or by confinement in the county jail for periods up to 6 months or both fine and imprisonment. Now, that's what they do in California.
Wow. So a misdemeanor in California, if I'm hearing right, Mr. Chairman, may I follow up? Okay, so if I'm hearing right, a misdemeanor in California can be fined more than $1,000. But do you know that?
Well, in this particular case, it's up to 10,000 and up to 6 months in the county jail.
Okay.
I wasn't asking to go down that road, though, so.
No, that's fine.
But, I mean, obviously, you guys can do whatever you want to with the bill. It's.
Well, I just want us to be within compliance, and naturally, Chairman Werkheiser will be working with our general counsel to make sure, but I'm just asking the question that was niggling in the back of my mind. Thank you very much, Mr. Chairman.
All right, number 26, Representative Carpenter.
Yeah, okay, so just a couple of things. I think I got a little nervous on the civil piece too, because it's my understanding that civilly means there's somebody on the other side of that lawsuit, and it would not be the state of Georgia, it would be a different party. Is that correct? Or would it be a civil suit from the Department of Labor to them? So it wouldn't be an individual?
It'd be from the department.
Okay. And then my next question is, I know we've talked a lot about the film industry, but you mentioned that you were a bagger. It was Walmart when you were 15, 16 years old. Mm-hmm. And what about a scenario on Friday night where Walmart's super, super busy, there's people lined up everywhere, it's 9 o'clock, you're supposed to get out of there. They say, hey, hold up, I know you're not supposed to be here till 9:15. Would Walmart at that point, because you worked past 9 o'clock, theoretically be fined $1,000 if the department so choose to fine them?
Well, I can tell you
under this
I can
change.
tell you for a fact. Of course, now back when I worked at Walmart, it was not open 24 hours. All right, it closed. Yeah, I know. Imagine how far back that was. We actually did close at 9, and it was very rare on the nights that it closed at 9 that I got to go home at 9, because then you had to go straighten everything up in the store that everybody had messed up that day. And so sometimes you got to go home in 20 minutes. Sometimes it took 45 minutes, which is always was a point of contention on a school night with my parents. But I mean, in the case where you did, I mean, yeah, you would need to be paying attention to that. But generally, what would happen if somebody complained, then they would probably get a visit from an inspector. It would meet with the HR person, whatever, and goes, you have somebody who's of this age, blah, 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 and the rules say this. Are you aware of that? And they go, oh, no, we were not aware of that. And go, well, you need to do that again, all right? Then if it happened again, then, yeah, they could be fined. Yes, absolutely, especially if they were, told to correct an action and did not. It is our policy that usually the first offense, unless it's something super egregious and you can tell it was willful, and we know, we just give them a warning. But even now, when we're really getting on to somebody, that's all we're really doing. It's just getting on to them. I mean, it's just like when if you ever get on to your kid, but then you don't, tell them they can't go out for 2 or 3 weekends in a row, there's no penalty. I mean, they don't really care. It's just they got to sit there and listen to you, get on to them for a minute, and then they just kind of go on about their business.
Okay. And then one follow-up question on the part about the administrative adjudication, the hearing. It's always been when dealing with the Department of Labor, it's always been a kind of a challenge for me in business, because I always felt like, even on unemployment claims, I was guilty until proven innocent. And those hearings are not like typical hearings that you have in a court of law. And so I always felt like, even though the person quit, walked out, said they were never coming back, I had to work myself to death to make sure that I was available at 3 p.m. on a Tuesday afternoon, even if I got chicken in the fryer, to defend myself. And so those hearings to me can be a little challenging and not kind of innocent until proven guilty. And so that would be my other concern or point about the legislation.
Well, aren't you glad that we did away with in-person hearings then?
Yeah.
Yeah, went to phone hearings, that solves some of those problems. But yeah, I mean, you understand a lot of the process when it comes to UI claims. a lot of that process is not set by the state of Georgia. That is set by federal rules and regs that we have to follow. And the matter of fact, after I became labor commissioner, we actually took out a lot of extra and unnecessary steps that streamline that process.
And I will say it's streamlined, but I still feel like that piece is, you're still going into a court of law on the other side, and it's guilty until proven innocent. That's my challenge.
And you know, and an interesting thing is I can tell you that we get the exact same complaint from claimants that are filing claims too. So we may have finally hit kind of the right balance if both sides think that it's unfair.
All right.
Casey, I was glad 20 years ago when the state ran out of money, and all of a sudden I wasn't as guilty as I was a few years before that.
All right, we've exhausted all the lights. Representative Marin, you never lit up. Is your microphone working? I mean, you didn't want to speak? You're good? Okay.
Do a motion, so. We have several other things that we need to do. Would love to just leave.
Well, we still got 1 minute till we're done with this room, so we're in good shape. I do have one quick question. Oh, now,
Are we gonna fix, and I know that General Counsel was sitting right next to me, and she thought that we had that bill, and then she was gone. We're gonna fix that, and
We're going to work on it and talk with interested parties. Again, this process got kind of pushed right up into the meeting, which is why we needed to have a hearing and kind of see where the committee was on this.
thank you.
One last question, though. There are some exemptions on child labor for agriculture and always have been, and this won't affect that at all the way I read it. Do you agreeing with that too? All right. No, Mr. Chairman, we appreciate this. I think just, I mean, as we're well aware, this committee looks at the little things that, you know, whether 99% of the time is right, it's that 1% that we got to go address, and we look at that all the time on everything. So appreciate you bringing that, and with that, we are adjourned.